All right, everybody, please join me in welcoming our next speaker. Gov Hutchinson is the Assistant General Counsel and Vice President of the California Association of Realtors. He's been with the association since 1985, managing the Member Legal Services Program in Los Angeles. He also advises realtors through the hotline on all aspects of real estate law, and he trains and supervises other hotline attorneys. Gov received his bachelor's degree in history from Princeton University and his Juris Doctorate from the University of Pennsylvania. Gov, as always, thank you so much for joining us today. I'm going to turn things over to you for the next hour and 15 minutes, and then we'll be joining again for the remainder of our program, where we're going to be featuring Dr. Campbell, the president of the San Diego City Council. So please don't go away. Gov, over to you.
All right. Hello, everybody. Good to virtually be with you. I wish I was, like Sanjay said, I wish I was there in person. It's always much better. I love San Diego. Actually, today in Los Angeles, it's about 80 degrees. So I don't know what it's like there. Of course, it's a nice day, but I can't enjoy it. I'm stuck in here, but that's okay. Hope you appreciate I'm wearing a coat and tie here. I haven't put a tie on for a few months, but I saw Sanjay had one on, so I had to put one on. So anyway, good to be with you for my annual update on the new laws, okay? And there are quite a few, as always. I'm not gonna talk about all of them, maybe 9 or 10. And you were sent a handout. If any of you wanna download, open up, you can sort of follow along. Otherwise, you can just get that handout later at your leisure and look at it. But we do an annual new laws for realtors handout that talks about all the new laws that affect real estate. And I am going to, and if you're interested, as I talk about a particular item, I'll tell you what page it's on and you can see it, okay? Before I even talk about the new laws, let me get one thing out of the way, the latest on COVID. The latest situation we're in, you all have been following this about the stay-at-home rules and all that stuff. I think the big thing to remember is, as I think another speaker mentioned, I mean, you're essential. You're always, you're essential. Realtors are considered to be an essential service. So however the changes happen in your area as to, the restrictions, indoor eating, not indoor eating, or, retail 20% open, retail more than that, all these periodic changes on these, these rolling tiers, they don't really affect you as realtors because you're still, no matter what, you're essential. And which means you can leave your home and go out and do essential things. But I think one thing you have to remember is when they say you're essential, that means you're allowed to go outside to do essential things that you can't do virtually. It doesn't mean you can do everything you used to do. I think this is going to be over soon, but right now, what that means is, I mean, obviously you can show properties, preview properties, inspect properties, appraise properties. Those things have to be done in person, right? I mean, you can't really do those. But there are other things that realtors do that probably can be done virtually, which means you should do them virtually, like a lot of marketing. Like, of course, you can use the mail and send things out in email, but you shouldn't be knocking on doors. You shouldn't be initiating face-to-face conversations right now. That's not considered something that's essential, that can't be done virtually right now. So just think about that. You know what a gray area is? Listing presentations. Are you allowed to leave your office to do a listing presentation? Some would argue, why can't you do that remotely? Some would argue, on the other hand, that how can I give a listing presentation without seeing the property? Well, of course, you're allowed to preview the property, but do you actually have to meet with the seller in the property once you've seen it? That's a gray area. I'm not saying you can't do it. I'm just saying you got to think about these things. Okay. All right. The other thing, remember, is they really tightened up the mask wearing rules throughout California. If you leave your home, you should be wearing a mask unless you're outside within 6 feet of people, more than 6 feet away from people, or you're inside by yourself, right? So obviously realtors, you're allowed to open up your real estate office, of course. But if you're in your real estate office by yourself, you don't have to wear a mask. Or if you're in the big office and you're in your little office that's part of the big office, you're good. But if you're in a space in your office with another realtor, you both should be wearing a mask, okay? Because you're not by yourself in a room, if you understand that. So that's sort of the latest on that. Got to keep up on that stuff. You got to be flexible, like you've been flexible all year. These things are going to develop. They're going to go away, hopefully sooner rather than later. And of course, they've made very clear no open houses. Some people ask, well, can I do an open house by appointment? And I say, yeah, you can schedule appointments, but to me, that's a contradiction in terms. Open, the word open means no appointment needed. That's what open means. So how do you have something open by appointment? It's either open or it's by appointment. You know what I mean? So you just gotta be a little careful. I mean, obviously you can have appointment after appointment. You can have consecutive appointments on a Sunday afternoon. Just make sure that one buying party at a time, and you allow enough time to clean the property, wipe down the property between the showings, and everybody wears the mask and doesn't touch anything. All right, that's the latest on COVID. Let's talk about new laws for 2021. I'm going to go sort of, the ones I'm going to cover are sort of alphabetical order as opposed to level of importance. The first one in your handout, if you want to look at it, it's on page 5. It's called Common Interest Developments. It's under the heading of Common Interest Development requires CIDs to allow 25% rentals. Prior to this year, if you're like me and you live in a house that's part of an HOA or a condo or a townhouse, did you know the HOA would have the right to tell you you can't rent out your unit, or only 10% of you can rent out your units, or you got to live there 2 years before you can rent out your unit, right? HOAs can no longer say that. HOAs, when it comes to residential single family homes, they have to allow at least 25%, right? They have to allow at least 25% of the property owners in the HOA to rent out their property. Can't be stricter than 25%. Now, what if you're in an HOA that doesn't have any restriction at all right now? So everybody can rent it out. That's fine. Everybody can rent it out. I mean, obviously, you got to think about lenders as well. And, you know, it's in your interest, probably in an association, to not have it too wide open, or it's going to affect individual unit owners selling their properties and buyers being able to get financing. But putting that aside, what if, let's say right now, your association doesn't restrict renting properties, and like 30% of the people in the association already rent their property? And then they pass a rule under this new law. They say, okay, no more than 25% can rent the property, but 30% are already renting it out. Well, those 30% are grandfathered in. They can continue to rent forever, as long as they live there. They can get a new tenant and still do it. But let's say that one of those people sold their unit to another buyer, and that buyer comes in, they don't have the right to rent out their unit because that property is already over the 25% that the association limited. Of course, some associations are still not going to limit at all. They don't have to limit, or they can have a higher, they can allow more people, but they can't restrict it to fewer people. Okay. So, and by the way, if you're renting out your bedroom or your garage, or you have an accessory dwelling unit in the backyard, that doesn't count as renting out your property. Okay. It doesn't count. So that's good. All right. The second one I want to mention is, actually, you know what? What I'm going to do is I'm going to check questions. Okay. Just the questions for me. I'm going to follow along as I do this. Let me catch up to this. You know, Debbie, I think you're asking me, Debbie Giamatti is asking me a question. Is there an update on the COVID vaccine for realtors? If so, what tier are we? I think what you're really asking me is, do realtors get special preference? In other words, there is something on the list of tiers, right? I mean, the first tier, of course, are, you know, first responders, nurses and doctors, right? They're the first tier. And another tier after that, it talks about certain essential services. It talks about sheltering services, and commercial, industrial, residential sheltering, real estate services. We don't know exactly what that means yet. So when we find out, we'll tell you. I mean, clearly, I think it means that people who like work in nursing homes, right? They're maybe property managers who have to enter people's properties, to fix things, right? We're pretty sure that they come under that fairly high tier. The question is just does an average realtor, who part of your essential job involves going into property, are you someone who's going to get that accelerated tier as far as access to the vaccine, or are you just going to be based on, like I am, just based on my age? We don't have an answer yet. Okay, so we'll keep it. You keep you posted on that. Someone else asked me, what about senior communities that say you must live there a year prior to renting? Right, they can't do that anymore. Okay, all right. What if there's only 3 units in the HOA? The rule still applies. What if the tenancy? What if the same tenant's in place? That's a very good question. So someone lives there, they have a tenant, the owner leaves, but the tenant is still there. Does the new owner, the buyer, assume are they grandfathered in? I told you the owner's grandfathered in, but is the new buyer grandfathered in? And I don't think they are. Of course, if that tenant's on a lease, they can't be kicked out till the lease is over. But I'm not so sure that just because it's the same tenant that's going to be the case. Not 100% sure on that one. Someone asked me, none of this applies to short-term rentals. None of these rules apply to short-term rentals. HOAs can completely prohibit short-term rentals. How does this apply to ADUs? I think I might have mentioned this. You can always rent out your ADU. And if you're renting out your ADU, that doesn't count as one of the 25%. Okay. And I have another question I'm going to talk to later when I talk about landlords. Okay. All right. Last question on that. If there's only 3 units and 25%, what is 25% of 3? Right. Well, if you think about it, 25% is actually less than a third. But I think that would be interpreted that at least one of the 3 can rent, if the HOA tries to prohibit the other 2. Okay. All right. Let's talk about another new law. It's on page 8 of your handout, consumer protection PACE liens. Remember what those PACE liens are? When a company comes to you and says, hey, you want to put in solar panels or something, you don't have to come up with the money. You can just finance it, and you can finance it with us because it's designed to, energy efficiency, blah, blah, blah. Of course, there are risks to doing these things because these liens have high priority. And if you get one of these PACE liens against your property, then it may be hard to sell the property because any buyer who comes along and tries to get a loan, get a standard conforming loan, Fannie and Freddie are going to say, no, we're not going to lend you the money until you pay off the PACE lien. We don't want to be junior to another lien. The point is there's a disclosure form that must be given to people when they get the PACE lien. The new law says, by the way, the first law on common interest subdivisions was AB 3182. This one is AB 1551. It basically says the PACE lien disclosure must be on a piece of paper in writing. It also says, let's say I do have a PACE lien. I want to sell my house. I realize I better pay off the lien or it's going to be hard to sell the house. The new law says the PACE lender cannot charge me a prepayment penalty for paying it off early. And the last thing this law says is if the property already has a reverse mortgage, you can't also get a PACE lien. Okay, all right. Third law I want to talk about, and I think this is the most important law I'm talking about today. So please pay attention. There is a new disclosure law. Do you know we haven't had a new disclosure law in several years? And I know you are all ready to have a new, don't you want a new, I mean, you don't have enough disclosures as it is. Don't you want more? Of course. Well, on page 13 of your handout, AB 38, the heading is disclosure and point of sale regarding home hardening and defensible space. Here's the deal. Starting January 1st, if you took a listing and the property that you have listed is a residential 1 to 4, and it's in a very high or high fire hazard severity zone, and it was built before 2010. If that's your listing, you got to give your seller this new disclosure form so they can fill it out and give it to the buyer. It's called the Home Fire Hardening Disclosure Form. So remember, it applies, it's a mandatory form on all residential 1 to 4, just like the TDS, but it's not required every sale. It's only required if you're in a very high or high fire hazard severity zone and that property is more than 11 years old. Okay, so I'm a listing agent. I get the listing. I figure out how old the house is. Now, how do I know if I'm in one of these 2 fire zones? Well, the NHD report that you always get, right? It lists 2 fire zones, 2 flood zones, 2 earthquake zones. One of the 2 fire zones on the NHD report is very high fire hazard severity zone, exactly one of the 2 zones I was mentioning. So if that box is checked on the NHD report, you know you got to provide this new disclosure form. Okay, what's the other fire zone on the NHD report? It's called the wildland fire area. If you're in a wildland fire area, does that mean you're in a high fire severity zone? No, you might just be in a moderate fire hazard severity zone. So I'm a listing agent. I get the NHD. The box is checked, very high fire severity. I know I got to do it. But let's say that box isn't checked, but the other box is checked, wildland fire area. Do I have to provide this form or not? Well, you have to investigate a little further. You have to find out, is this property in a high fire hazard zone or is it just in a moderate? You already know if it's in a very high because that's checked on the NHD report. So how do I know if I'm in a high or very high? I'm a high or moderate. You really have to ask your NHD rep. And all the NHD companies are aware of this new law. And my impression is they're all sort of working to be able to provide this information to you, or they're actually going to put it on the report. So I'm confident that if you have a listing and you ask your NHD rep, they'll be able to tell you if you're in a high fire hazard severity zone. Of course, you already know if you're in a very high because that box is either checked or not. So let's say you are in one of these zones and the house is built before 2010. You simply get this 1-page disclosure form out and you have to give it to your seller, and the seller has to answer some questions. And then when the seller's answered the questions, you give the form to the buyer's agent. What this form does, it really does 3 things. Number 1, it basically has some basic disclosure language to the buyer that says, hey, buyer, you know, you're buying a house in a fire zone. So you might want to think about taking some steps to harden the property to make it less vulnerable to wildfires. Okay. The second part of the form, as I said, the seller has to answer 6 questions. The questions are, do you have a wood roof? Or do you have single pane windows or double pane windows? Do you have certain type of gutter coverings? They're basically asking the seller, do you have features on your property that make it a little bit more vulnerable than it should be since you're in a fire zone? By the way, if the house was built in the fire zone after January 1st, 2010, it was built under the new fire code, and it automatically doesn't have a wood roof, has the right type of windows, has the right type of gutters, etc. So that's why the form isn't even required on homes built after January 1st, 2010, because they're already in compliance with pretty much all the home hardening things you can do. But if you're in a fire zone and your home was built prior to 2010, your house may not have all these nice home hardening features. So you've got to tell the buyer, hey, buyer, you're in one of these zones. And number 2, these are the features that I don't have. Of course, this may say to the buyer, well, then I'm not going to buy your house unless you fix the windows or something like that. It's going to be a negotiation. It's not like you have to do it, It's not required to change your roof or your windows, but it's going to be an issue probably. Okay. And then the third thing on this form, it mentions to the buyer, it says the seller's, it says seller, if you have a final inspection report regarding fire hardening, give it to the buyer. What does that mean? Well, let's say I own a house in one of these areas. It was built before 2010, but about 5 years ago, I did a major, I actually had fire damage, so I had to rebuild. Well, since I had to rebuild, even though it was after January 1st, I had to make my rebuild comply with the new rules. And then the government, the local government building official would have given me, they had to give me a final inspection report certifying that my rebuild, my reconstruction is in compliance. So if I'm that person, I've lived in, this house is older than 2010, but since then I've had fire damage and I fixed it. And I got, which means you would have got this final inspection report. All this new form reminds you to do is give this to the buyer. So it's 3 steps. It's telling the buyer they should think about doing things. You're telling the buyer any features you have that are less than perfect. And number 3, you're reminding the seller, I got to give the buyer this form. Of course, you want to give them this form. It's a good thing. Okay. So that is the new form. That's actually the only new form that came out recently. And it's the most important new form because it's mandatory. But if you remember, if you're not in a fire zone or the house was built after 2010, you don't have to do the form. You only have to do the form if you're in the fire zone and it was built prior to 2010. Okay. If it's a probate sale, you're exempt. REO sale, you're exempt. If it's a trust sale and the trustee never lived in the property, you're exempt. If it's a bankruptcy sale, you're exempt. In other words, if you're exempt from the TDS, you're exempt from this form. And even if you're not exempt from the TDS, if you're not in a fire zone and it wasn't built before 2010, after it wasn't built 2010, you're also exempt. So not everyone has to do it, but it is a mandatory form. And you know what? It's interesting. For the last, I'd say 15 years, when people ask me, hey, Gov, could you tell me once and for all, what are the mandatory disclosures? And I've always been telling people, the way you should think about it is NHD +4. Because if you get an NHD report, that takes care of a lot of the disclosures. All you got left are 4 more things: the TDS, the seller property questionnaire, the federal lead paint form if it's pre-78, and then the 4 disclosure booklets, right? So NHD +4. Well, you know what? For the last 2 weeks, I have to say NHD +5. See what I'm saying? NHD +5, because there's now a 5th mandatory disclosure form. Now, a couple of you asked the very good question. Actually, 3 of you, or 2 of you asked the very good question. Okay, we got into escrow prior to January 1st. Is the form required? The way we read the law, we don't think so, but we're not 100% sure. So that means the conservative advice is yes, even though you got into escrow prior to January 1st, if your property is in one of these areas built before 2010, I would give them the form. Okay. You need to do that. Okay. Okay. Let's see if there are other questions on this. Yeah, the home fire hardening disclosure form, HHDA, does not apply to leases or property management. Yes. Someone asked a question related to forms here. I said that's the only new form. So the question someone asked, are there any new forms for landlords for tenants not paying? Let me get to that in a second. That's a good question, Annie, but let me get to that in a second. All right. The next law I want to talk about, so we've covered renting out condos, we've covered PACE liens, we've covered new important disclosure law. Next law is back to COVID. It's on page 17 of your handout, AB 685. And we just released a Q&A on this topic day before yesterday. It's on our website under, just look for AB 685, search for that. Here's a new law. If you're a broker or you're any business owner and your office is open and you got people working in your office, for a broker, that means you got agents or other people working in your office. People work out of the office. And someone who works out of the office gets tested COVID positive. The new law says, if this happens, you, the broker, you, the business owner, must provide in writing by the end of the next business day a notice to anyone else who works in the office. Basically telling them, number one, someone in the office where you work tested positive. You don't have to say who it is. Number two, this is what I'm, as the business owner, am doing to disinfect the property. And number three, these are the company benefits you have, such as sick time, leave time, COVID relief time, whatever. Now, every company is going to have some different, different company policies regarding this. But the point is, by the end of the next business day, when this happens, you're going to have to, in writing, notify anyone else who works in the office what their rights are, what you're doing to disinfect, and the fact that it happened. Now, you don't have to give this to the people in your company who don't work in the office. Maybe you have some agents who never, ever set foot in the office. Maybe your office isn't even open. Maybe it's open, but the only people that goes in is you. I mean, if people, you don't have to give this form to people who never come to the office. But what if the office is open, they can come in if they want, but they haven't come in yet? Well, of course, you're going to notify them, don't come in for the next period of time until we get it clean. Similarly, let's say you have an agent, the one who gets sick is someone who never ever comes in the office, has not been in the office for months. Well, you don't have to disclose that to anybody because they're not in the office. Of course, you're going to tell your agent, common sense, don't come into the office until you're not sick anymore. And of course, remind that agent that when they're out there doing real estate, obviously, if they want to go see a property, or they probably should quarantine themselves, obviously, but they always would have to disclose that they actually have COVID if they're showing their own house or they're showing someone else's house. And obviously, they really shouldn't be doing anything, right? Because you're supposed to quarantine yourself for a certain number of days, which leads to another question not related to this law. I'm a realtor. I had COVID 2 months ago. That was a long time ago. And I'm out there working. I'm out there showing properties, listing properties. Do I have to disclose on the PED form that I used to have COVID? But I don't anymore. And our advice on that one is you probably should keep disclosing it until you get a negative test. Once you get a negative test, we don't think you have to disclose that you used to have COVID, right? But if you haven't got that negative test, even though it was a while ago, the safe, conservative advice, legal advice that we're giving you, we don't want any possibility of a legal problem, is you disclose. You disclose, I had it 2 months ago. I had no symptoms then. I haven't had any symptoms since. But you don't have a negative test. Okay. All right. So that's the latest on that one. By the way, before I go on, someone asked me a question, got nothing to do with what I'm talking about, but I'll answer it. I had a couple of situations where the client did not want to provide the TDS. What do you do when your client doesn't want to provide a TDS? Well, if you're the listing agent, you tell them you're legally obligated to do it. If you don't do it, you could get in trouble and get sued if there was something that should have been disclosed. Plus, if you don't do it, even if there was nothing to be disclosed, by not doing it, you're giving the buyer the right to cancel the deal anytime they want, right up until the closing day, because buyers have a 5-day right of rescission after receiving the TDS. And if you never give it to them, they still have their 5 days. And plus, you, the realtor, even if your seller, for some strange reason, doesn't want to provide the TDS, you have to do your visual inspection and disclose in writing, preferably on the Avid form, what you disclose. I'm not sure you even want to deal with that type of client who won't even sign disclosures. It's almost like you're asking for trouble. But if you still want to work with them, you know, the buyer's, of course, going to ask, where are the disclosures? And the buyers might not want to go through with it without it, or they go through with it, they find out a problem later, the seller has a problem. All right, let's keep going. Next law I want to mention is, my friend Barbara Dudek's asking me, does what I was talking about before pertain to those who've not been in the office lately? I mean, remember the whole issue is you're trying to protect people who come into the office. So if they say they haven't been in the office lately, does that mean they might come in? You know, I mean, if there's any possibility of the agent coming in, I think you got to notify them. Or you don't have to necessarily give them the form, but you got to notify them. Someone who works in the office is COVID positive. So, and by the way, this Q&A that I mentioned actually has a nice template. You don't have to figure out your own form. It gives you a template so you can do your own form. I'm sorry, that was on page 17 of the handout. It's under the heading Employment Notification of Employee of COVID-19 Exposure. Renee, based on the OSHA guideline, you can't disclose at all who has COVID. Right, you don't disclose who the person is, you just disclose that someone in the office, right? Very good question. Debbie, I'm going to talk about Prop 19 later. Virginia asking me, where is this new packet located? All I can tell you is I got the same invitation to join this meeting that you got, and it's right on there. It's linked there. You can click on it and open it up. Okay, on the invitation you got to this meeting. Okay, all right. Next one I want to talk about is on page 23 of the handout. The heading is Foreclosure Tenants and Prospective Owner Occupants and Nonprofits' Right of First Refusal. This is kind of interesting. It's not directly related to your job, but I think it's something you really need to know about. Let's say there's a house, a single family house being foreclosed on, right? By the way, are you allowed to foreclose right now? Yeah. Some of you should know that foreclosures are happening in California, but if you own a property and you can't pay your mortgage because of COVID, you're sick, you've lost income, or you have a tenant who's not paying rent because of COVID, your California lender, your servicer in California is required to offer you some type of forbearance, which is a fancy word for delay. So they have to give you more time to make those payments, so they can't really foreclose on you right now. But let's say it's not that situation. It's just a normal situation, a normal foreclosure, single family home. So there's a foreclosure and somebody goes to the auction and they win. It's their property now, right? Not so fast. If they're planning on living in the property they just foreclosed on, yeah, they're done. But let's say an investor is foreclosing. Okay, let's say an investor is foreclosing. If they're foreclosing on a tenant occupied property, that tenant has 15 days. That tenant has 15 days to submit an intent that they want to buy the property. And then if they submit that within 15 days and then come up with the money within 45 days, they can force the person who won the auction to give it to them. All they have to do is match the price. Well, let's say it's not tenant occupied, or it's tenant occupied, but the tenant's not trying to do this. If the person who's foreclosing is an investor, anyone out there who wants to occupy that property can also submit within 15 days, an intent to bid. And then after 15 days, if the tenant doesn't do it, they're actually going to submit a bid of how much they want. In other words, they can bid above the price. You would think if that person wanted the property, they would have gone to the foreclosure auction, right? If they're willing to pay more now, why weren't they willing to pay more then? The point is, keep this in mind. And it even applies to certain nonprofit housing providers. They also have this right, 15 days to submit the intent and 45 days to come up with the money. And guess what? Even if someone doesn't submit the intent in the first 45 days, in the first 15 days, if they can come up with cash, even after the 15 days, before the 45 days, they can get the sale. So in other words, if you're an investor at a foreclosure, you're not really sure you have the property until 45 days. Okay, very interesting, right? All right, what I'm talking about right now is, yes, this applies if the bank holds the sale and the investor is the winning bid. Okay, and this is on page 23 of the handout, SB 1079. By the way, CAR opposed this in case you're interested, but we don't always win. And the trustee's website has to have all this information on it of like what the status is and what the bids are. So you should be able to figure this stuff out if you're trying to do this, okay? I got a good question here. Let me go back to COVID. Properties for sale, tenant just learned that the tenant has COVID. All showings were canceled until then. Property's taken off the market. Seller wants to see written proof with the tenant's name on it listed that he has COVID. Seller thinks the tenant's not being true. So what do you do if your own tenant tells you, I got COVID, you can't show it, and you don't believe your own tenant that they really have COVID? You think that's just their ruse to try to prevent showings. You know, I think it's a reasonable request to have some type of proof or substantiation that the tenant really does have COVID. I mean, that's reasonable. I think that's reasonable. If I were the judge, I would say that's reasonable. But what if it's a real tenant-friendly, COVID-friendly judge? I don't know. So yes, the best advice is not you giving them this advice, or not saying my attorney Gov says this is okay. It's even better if you say to your seller, you need to get legal advice as to how far you can go, demanding that the tenant, what type of proof you can demand that the tenant provides to say they really have COVID. If I were the attorney that was referred to, I'd say, I think you can reasonably ask for that. So yes, someone asked me, yeah, up to 40, getting back to the other thing, up to 45 days, buyers can get a loan to purchase. Where is this in the booklet? What I was just talking about, remember page 23, SB 1079, under the heading of foreclosure. All right. Someone asked me, he says, when you open up the handbook, it says 2020 rather than 2021. Well, when I opened it up, it was the right laws. I didn't look at the heading. Maybe the heading's not right, but okay. And by the way, getting back to this same situation we talked about, what about tenants who are behind in the rent because of COVID? Can I sell the house and get them to move out? I'm going to address that in a second. That is a new law. And getting back to the same question, tenant provided a generic email saying he has COVID. Once again, my opinion, they need to provide more proof than that, but send your seller to an attorney, okay? That'd be the safer thing to do. All right, next, page 25, also on foreclosure. I've already mentioned this, and that is on page 25, AB 3088, under the heading foreclosure and forbearance protections. Single-family homeowners, which includes small landlords, are entitled to foreclosure forbearance if, I mean, used in most states, this is only if it's an FHA loan or a VA loan or something like that, or a conforming loan. In California, all mortgage servicers who have someone who can't pay their mortgage for COVID reasons, they have to follow the same guidelines as if it were a federally related loan, even if it's not a federally related loan. In other words, there are some details here. Not everyone's entitled to the same type of forbearance, but you're entitled to whatever the forbearance is offered under the federal guidelines, even though this is not a federally related loan that you're dealing with. Okay, all right, that was pretty quick. Next one I want to talk about is on page 28 of your handout, AB 1885, on the expansion of the homestead exemption. This is kind of interesting. Do you know what the homestead means? Okay. Everybody in California, if you own a house, regardless of how much equity you have in the house, you have what's called a homestead exemption. This protects you against unsecured judgment creditors. It only applies to your principal residence. It only applies if you're a natural person. So if the property is owned by a corporation or something, it doesn't apply. But a natural person, principal residence, someone gets a money judgment against you. Can they put a lien on your property and foreclose on your property? Only if their judgment is high enough to pay off the mortgage and any other liens and pay you your homestead amount. Up until January 1st, this is what the homestead amounts were. $75,000 if you're single, $100,000 if you're head of a household of more than one person, $175,000 if you're over 65 or over 55 and disabled. So let's say me, right? Prior to January 1st, let's say that means I have a $100,000 homestead, and let's say I owe $100,000 on my mortgage. And someone sues me and gets a judgment for $199,000. They can't touch my house because they don't have enough money in the judgment to pay off my mortgage and pay me my $100,000. But if they get a judgment for like $400,000, they could, if they wanted to, foreclose, pay off my mortgage, pay me my $100,000 and keep the rest because I had a $100,000 homestead. Well, guess what? As of January 1st, my homestead is not 100,000 anymore. It's 600,000. Here's the deal. Everyone in California, your homestead amount doesn't depend on whether you're single, household, or how old you are. Everyone has a homestead now of 300,000 or the median sales price of a single family home in your county the previous year, with a cap of 600,000. So I live in LA County. The median sales price of a home in LA County last year was over 600, which means every homeowner in LA County now has a $600,000 homestead on their principal residence. San Diego County, you tell me, you figure out what the median sales price of a single family home on the last year was in San Diego County. Let's say, I don't know, maybe it was over 600, maybe it was 500, whatever it was, that's what your homestead is right now, unless it was over 600, in which case you're capped at 600. What if you're in a county, and there are some counties, many counties actually in this state where the median sales price last year was under 300,000. Well, they still all get a 300,000 homestead, okay? So that's interesting, right? Okay, someone told me that they think it's 750K, which means someone tells 640. So everyone in San Diego County, you all have a $600,000 homestead. So let's say you own a house, $1 million, it's worth $1 million, and you owe the lender 200,000. Someone gets a judgment against you for 799,000. They can't touch you. there's no lien attached to your property because they didn't get enough of a judgment to be able to pay off the homestead plus the secured lien. Okay. All right. Next one. And now I'm going to finally get to some of the questions you've been asking about rentals. What's the latest on rentals? So on page 33 and several other pages, there is summary of laws regarding landlord, tenant, and COVID. It's AB 3088. And I'll tell you the latest on that. First of all, there's a law in place right now. Before I go any further, someone asked me a very good question. Does the homestead I just talked about need to be recorded by the owner? Answer is no. You get this automatically. But you should all record it anyway, because by recording it, you're not only protected from a foreclosure, you're also protected if you try to sell the house. They can't put the lien on the proceeds during the time in between the sale and the buying a new one. So you all want to, everyone needs to record this, but even if you don't record it, right? Even if you don't record it, you still get the benefit that I just described. Okay, but I would still record the homestead. And someone asked me, yeah, even with the homestead, an unsecured creditor can still garnish your wages, right? Yeah, they can still do things like that, which may indirectly force a foreclosure. You're right. What if you have multiple properties? Remember, this only applies to your principal residence. You can only have one principal residence. Okay. All right. You got to just go to the recording office to record this document. No, unfortunately, the homestead doesn't protect you from IRS liens, child support liens, mechanics liens, voluntary liens, mortgage liens. And if the house is in a trust, the rules are the same. This doesn't change anything. Okay. All right. Let's talk about rentals for a second. Okay. There's a law in California right now that expires January 31st. 2.5 weeks from now, that the law is over. Is it even worth talking about? It's going to be over in 2.5 weeks. Well, did you remember what Sanjay just said? It looks like it's going to be extended at least 3 months. Maybe not. We don't know. But let's assume that's the case, right? So you need to know about the law that's in effect right now, because it's probably going to keep on going. What this law says right now is, number one, let's talk about evictions. You want to evict someone, you got 3 reasons why, right? Number one, they're not paying you. Number 2, they're paying you, but they're doing something else bad. Or number 3, you just want them to leave because you're selling the house or whatever. The third one is called no fault, right? Let's talk about all 3. First of all, what if a tenant is not paying you rent? Can I evict them today? Yes, you can, unless the reason they're not paying is COVID. So remember, there was a whole freeze on evictions for several months. That ended October 1st, but that doesn't mean you can evict everybody. It just means you can evict people who aren't paying and they don't have a COVID reason. Well, how do I know if they have a COVID reason or not? All you can do is serve them with an eviction notice and see if they respond with the declaration of COVID financial distress. Okay. So if you got a tenant not paying you rent and you want to try to evict them, you can submit the eviction form, see if they don't respond with that other form, you can go ahead with the eviction. Now, the problem is, I hope you all know this, if you're going to send someone a 3-day notice, you can't send the normal 3-day notice to pay or quit. There's a special 15-day notice to pay or quit. And all these forms I'm about to talk about are on zip form in the category of COVID forms, but there's a 15-day notice. Well, can I start using the 3-day notice? When can I start using the 3-day notice? Well, I would say February 1st, but as Sanjay said, I wouldn't be at all surprised if that doesn't get extended. But let's just, as of now, it ends January 31st. Okay, second category, tenant, it's not an issue of paying the rent. So in other words, if they have a COVID reason, you cannot evict them. If they don't have a COVID reason, you can evict them. But even if they have a COVID reason not to pay rent, they still owe you the money. And you can sue them for the money right now. Not as part of an unlawful detainer, just as a lawsuit. And starting March 1st, you can sue them for more than $10,000 in small claims. Let's say a tenant hasn't been paying you for 8 months and they owe you like $30,000. You can sue them in small claims court March 1st. You can sue them today for 10,000 small claims, but March 1st, you can sue them for unlimited amount. Okay. Second question, tenant, the issue is not paying the rent. The issue is they're violating some other term of the lease. They have subtenants illegally. They have pets illegally. They're creating a nuisance. They're damaging the property. They're engaging in criminal activity. They're not allowing you to show it. Those are all violations of the lease. You can evict them right now. 3-day notice to cure breach of covenant or quit. Yes, we have you can't use the regular 3-day notice to cure. You got to use the special COVID 3-day notice to cure, but you can do that right now. Unless, of course, as I said, that if the tenant actually has COVID, you can't really evict them right now. Okay. Let's go, but okay, let's say the tenant is, they've had pets they shouldn't have, subtenants they shouldn't have, they won't allow you to show it. And you give them the eviction notice, they says, oh, you can't evict me because I got a COVID issue. And you're going to say, I'm not evicting you because you're not paying the rent. I'm evicting you because you're violating some other term. It doesn't matter whether you're paying the rent or not. It doesn't matter whether you have a COVID reason or not. You see what I'm saying? All right, now let's talk about the third category. I want to evict the tenant who didn't do anything wrong. It's a free country, right? I can have it once the lease is over, I can kick them out, right? Normally, I would say yes. If it's a single family home, or if it's an owner-occupied duplex, or if it's a building less than 15 years old, you can evict a tenant. You don't need a reason. Unfortunately, until the end of January, and maybe for a couple 3 months after that, you cannot evict any tenant residential in California, even on a single family or duplex or new building, without just cause. Now, just cause, obviously, they're not paying the rent, they don't have a COVID reason, they're violating another term of the lease. But is there any just cause reason to evict a tenant because, I just want to kick them out? Well, there are 3 legitimate reasons to evict a tenant for no fault. Number 1, you want to move in yourself. You, parent, grandparent, grandchild, grandparent, parent, child, grandparent, grandchild, not brother, sister, cousin, parent, grandparent, grandchild, child. If you are or spouse, you can even separate from your spouse. It's easier than divorce. Just separate from your spouse. One of them can move into the rental, and that's grounds to evict the tenant. Okay. Second way to evict a tenant for no fault is you want to take the house off the rental market. You just don't want to be a landlord anymore. You can kick them out, assuming the lease is over. But that means you can't re-rent it, right? You've taken it off the rental market. Well, how long do I have to take it off the rental market before I can re-rent it? Probably at least a year. Third category is what you all want to know about. Very interesting. You should know this if you don't know already. If you're selling a single family home and you find a buyer who wants to live there, and once you're in contract with this buyer, you can give the tenant 30-day notice or 60-day notice. It doesn't matter whether they have a COVID issue and not paying the rent or not. It doesn't matter anything. Even if they have a COVID issue and they can't pay rent, you can still evict them because you're selling the house to a buyer who wants to live there. But you can't give the tenant the notice until you're in contract with the buyer. Okay? Now, if nothing happens, 2.5 weeks from now, we're back to normal. You can do whatever you want. But let's assume they extend this California law another 3 months. By the way, federal law, every state, it's not just California, every single state in the country right now, there's a nationwide eviction moratorium for COVID issues all the way until February 1st. So don't complain about California on this one. This is everywhere. The federal law might get extended also, even if the California law doesn't get extended. Who knows? You just have to, if you're a landlord, you got to be flexible. Realtors, you got to be flexible. I'm just telling you what the situation is right now, okay? That's where we are right now. By the way, someone asked me, the homestead, yes, principal residence, could be a condo, could be a mobile home. Can a tenant, related to it, can a tenant simply refuse to allow showings because they're uncomfortable with COVID? And the answer is no, unless you're in certain counties, like Los Angeles. In LA and some Bay Area places, tenants do have that right. In San Diego, no. In San Diego, the tenant doesn't have the right to say that, okay? Here's an off-the-wall question, but it's a good question. What if the tenant is a sex offender, but they never disclosed that when they rented the place in the first place? Yes, that is grounds to evict. Someone else asked me, is this being recorded? I believe it is. So yes, you can listen to it again. Another question, I have a client with a condo rented to a tenant. There's no lease. Can he give him a 30-day notice? Well, not unless you have one of the just cause reasons I just mentioned. You can only evict this tenant if you want to move in, the seller wants to move in, you find a buyer who wants to live there, you want to take it off the market, they're violating some term of the lease, or they're not paying the rent and they don't have a COVID excuse. If that's your case, yeah, you can give them a notice. And 30 days if they've been there less than a year, 60 days if they've been there more than a year. But just because there's no lease doesn't mean you can evict them. What if I got a tenant on a lease and the lease is about to end? Can I evict them? You still need one of these reasons, at least till the end of January. How much notice is required to the tenant if the owner is selling and they get this buyer? Once again, if the tenant's on a lease, you can't evict them till the lease is over. Okay? Now, if they're a month-to-month tenant, you have to figure out how long have they been there. More than a year, 60 days, less than a year, 30 days. But here's an interesting thing. Tenant's been there like 3 years. You get a buyer who wants to live there. And the buyer puts on the purchase contract, they're going to live there for at least a year. If they put that on the contract, you can give the tenant a 30-day notice. What if an investor wants to buy the house? That doesn't change anything as far as the issue regarding the tenant, okay? Yes, I think I already answered this. If there's a lease, buyer has to wait till the end of the lease. You can never kick out a tenant until the lease is over. Now, one of you asked me, is this the CDC law? What I have just been telling you is the California law. But remember, I also mentioned there is a federal CDC law too, which is very similar. And they're both going to expire on the end of January. The reason I don't care about the CDC law is because the California law is stricter and the stricter law prevails. Like the CDC law in other states, it doesn't apply. Tenants who make over 99,000 don't get these rights, things like that. But we got to go with the California law because the California law is stricter. So that's why I'm not really talking about the CDC law. Okay. Yeah, Ginger, I answered your question. I think the lease runs out. You can't evict them, even though the lease is over, unless you have one of those just cause reasons. Katrina asked me, what's the name of the 15-day form? I think it's just called the 15-day notice to pay or quit. I actually have it right here. How do you like that? It's the It's the notice to pay COVID transition period rent or quit, form PRQTP. All right. I'm going to keep going here to answer questions. I'm going to mention one more thing real quick on Prop 19. Yes, if a tenant doesn't allow a showing, that's great. That's a basis for eviction. Yes. Can I evict a tenant because I want to take back the property to remodel it? No, not until the end of this month and maybe longer. You can only evict them if you get a buyer and the buyer's in contract to buy it and live there. You can't kick them out because you want to remodel it to sell it. Maybe in 2.5 weeks, you'll be able to. Someone asked me, can you list with the condition the owner occupied buyer only if leased? Not really sure what that means. Okay. What do you have a court approved eviction and the sheriff states we've stopped doing evictions? Well, if the sheriffs aren't going to do it, you're pretty much stuck. Okay. How do you get a buyer that wants to live there? Yeah, you can of course have showings. I mean, just because there's a tenant there, they got to cooperate with showings. Of course you can sell it. Once you get an accepted offer, that's when you can evict the tenant. Okay. Are tenants in Imperial County allowed to prevent agents from showing? I don't think so. Call the CAR legal hotline. We can check it out for you. I'm pretty sure it's only LA County and some Bay Area counties. Courts are open for judgments. Yes, and I assume the sheriffs are doing lockouts. I don't know. Can landlords increase rents? Yes, you can still increase the rents. No restriction if it's single family. If it's not single family, you got to go with the 5% plus inflation thing. And you got to remember, some cities, I don't know if San Diego City or county may have restrictions on increasing rents. I'm just saying under California law, it's okay. I'm gonna get to the last question, but I promised real quick to mention Prop 19. Sanjay talked about it. And I'm not going to get into the whole intergenerational transfers. I think Sanjay gave the good answer. If it weren't for Prop 19, this is probably going to go away anyway. But as far as the part of Prop 19 that says that you can sell your existing house and buy another house and take your property tax with you. Remember, you've already got Prop 60 and 90. So if you live in San Diego County and you're over 55 and you sell your house, you can buy another house equal or lesser value and you can transfer your property tax right now. And you can also move to LA, Orange, Riverside, San Bernardino, or Ventura County. All Prop 19 does, it says you can do this 3 times instead of once. And you can move anywhere in California, not just the counties I mentioned, and take the property tax with you. And you can even buy a more expensive house. And when you buy the new house, you get a blended rate. In other words, it's not going to be paying property tax based on the purchase price of the new house. It's going to be a lot less than that. It's not going to be quite as low as you had, but it's a blended rate. Okay, so the only question on Prop 19 is, when does that take effect? And the answer is April 1st. So the next question is, well, do I have to wait to do April 1st? Or can I sell the first house now and buy the new house after April 1st and then transfer the property tax at that time? We think that's the answer. That's what we believe the answer to be. But the assessors and the Board of Equalization says we're not going to do that unless we have legislative guidance. So we are about to, probably today, going to submit a bill in the legislature to clarify that you don't have to wait until April 1st to sell the existing house if you want to transfer your property tax base if you're over 55 or disabled or a victim of a fire. But remember, if you're not leaving this area and you're buying a cheaper house, you can do anything. You can do it right now. It's only if you want to go beyond north of LA, Ventura, or you want to buy a more expensive house that you may have to wait till April 1st. Okay. All right. No, 60 or 90. Okay, you're right. It's not crystal, Lauren, good question. It's not crystal clear. That's another thing we're getting clarified legislatively, whether 60 or 90 are going to go away. The way we hope it's going to work is you're not going to need 60 or 90 because everything you get with 60 or 90 is going to be, you're going to get with Prop 19. Okay. Question. So in other words, the forms that I mentioned, the COVID forms, the special 15-day notice, to the notice to pay COVID protected rent, the special notice to cure COVID violations, even the notice to terminate tenancy. Remember I said you can give a tenant a 30-day notice or a 60-day notice if you're selling the house to a buyer who wants to live there. You're not going to use the regular CAR 60-day notice, notice of termination of tenancy. You're going to use the notice of termination of tenancy COVID. And that'll be clear to you because it's on zip forms. It's going to basically tell you which form to use. If you try to use the other form, it's going to tell you right there, don't use this form right now. Okay. In a perfect world, this would all go away January 31st. And we'd be back to normal on evictions. You and I are both thinking that's probably, and Sanjay was suggesting that's probably not going to be the case. Landlords are probably going to have to deal with this. But last bit of good news, I don't know if you heard, I think from your NAR speaker, the good news is money is coming to California to compensate landlords for tenants who aren't paying their rent. And we believe the new administration is going to increase that money. How much rent do you think back rent tenants owe California landlords right now for COVID rent that they didn't pay? Answer, about $6 billion. Well, under the law that was just signed, how much money is coming to California to compensate landlords? It looks like about $2.5 billion, so not $6 billion. But we think the new administration, the new Congress are going to increase that money. So there is going to be a way finally for you landlords to get money that tenants didn't pay you. That doesn't mean you're going to be able to evict them necessarily right now. And that's still an issue, obviously. But the monetary issue, because a lot of the landlords are saying, this tenant owes me 10 months rent, I'm never going to get that. And yes, Carmen, good question. If the landlord gets money from the government, they can't go after the tenant for that same money. But let's say the tenant owes you 6 months rent and the government gives you 3 months worth. The tenant still owes you the other 3 months. What we're waiting to figure out now is what's going to be the process in California to apply for this money. It hasn't been set up yet. It's not even clear which government agency is going to handle this. Obviously, as soon as we know, you will know immediately, right? Okay. All right. Let me think, see if I skipped any questions. Is it a violation of fair housing for a listing agent to require a pre-approval letter from a lender in order to simply view the property? No, as long as you apply that for everybody. You don't make any exceptions to that rule. As long as you treat everyone the same, it's not a fair housing violation. So if you want to be that strict, you can't even see the property without a pre-approval. If you apply that to 100% of your applicants, then that's okay. All right. Someone asked me, notice of termination of tenancy. Okay, let me make one thing clear. Remember I said the only reasons you can evict a tenant right now for no fault are you want to move in, you want to take it off the market, or you have a buyer who's going to live there. Well, what if I need to do repairs on the property? Well, yeah, you can kick them out temporarily while you're doing the repairs, but then you got to let them back in. You can't kick them out permanently for doing repairs right now. That'll change at some point. What if there's massive problems to the property. I really got to, can I kick a tenant out for that? Well, listen to this. You can only use that excuse is if these massive changes are required to make the house habitable, their health and safety. Well, think what I just said there. If you're going to try to use that excuse, you're admitting that the rental property that you're the landlord of is not health or safety, which is a violation in and of itself. So I don't know if you want to be using that excuse right now to evict the tenant. Okay. It looks like we have answered all the questions. If you have more questions, please call my people at the CAR legal hotline. You know that I'm the manager of that. So all those people I know, they're waiting to talk to you. They want to talk to you. Okay. Someone asked me 30-day notice apply to Section 8. Good question. Thank you, Manho, for asking that question. If you got a Section 8 tenant and you want to kick them out and you have one of these reasons, you first have to give them a 90-day notice to terminate the Section 8. Then, and only then, can you give them the 30 or the 60. Thanks for raising that. I should have mentioned that. Very good question. One of you asked me for my cell number, so you can call me anytime. I would love to do that, but I can't. I'm so sorry. Let's see. Do you need to let a lease go month to month, or can you ask the tenant? Oh, there's a good question. It's not exactly precisely what was asked, but maybe I'll make this the last question because I know we got another speaker coming. Remember I said if the lease ends, normally, if we weren't under this special law, when the lease ends, you kick the tenant out, no problem. Right now, the end of a lease is not just cause. If they want to go month to month, they can go month to month. But guess what? Let's say right now you have a lease and the lease is about to end, and you say to the tenant, you know, I want you to sign a new lease. Tenant says, no, I'd rather stay month to month. That's grounds for eviction. That's grounds for eviction because the tenant refuses to sign a new lease. And mostly landlords don't want that. They want the tenant out. But it is grounds for eviction. It's just cause if a tenant won't sign a new lease. I said it was the last question. Let me do one more. It's been asked a couple of times. Remember I said the only new form is the home hardening advisory, and that's true. But someone asked me at least twice about the COP form, contingency for sale of buyer. I heard that's a new form. The form, it's not a new form. It's just been tweaked a little bit. Remember, that's the form where the buyer says to the seller, my offer is contingent on selling my house first. The tweaks to that form are now on this form, the buyer promises the seller to keep the seller updated on the status of your escrow. If your offer is contingent on selling your house first, you have to tell the seller if they ask you, you know, has your buyer met all their deadlines? Have they removed all their contingencies, et cetera, et cetera. And the other thing, and this is the last thing I'm going to say, and then we're going to be out of here, I'm going to be done, is the other change to the COP form is, remember, if the buyer makes their offer contingent on selling the house and the seller accepts that, and then the seller later on gets a backup offer, they can tell the buyer, hey, since I got a backup offer, you have 3 days to remove this contingency and your loan contingency. Well, how do you notify the buyer you got this backup offer? Well, now there's a place on the COP form itself where you can use that form to notify the buyer you got the backup offer. And with that, I am going to conclude. It's been great talking to you guys. I can't wait to see you all in person. Hopefully that's sooner rather than later. If you have any more questions that you didn't get a chance to answer, please call the legal hotline. You can email me too, govh@car.org. Sometimes it takes me a little while to get back to you, or just call the legal hotline. You've asked, thanks for asking all the very good questions you asked. And now I'm going to send it back to Ryan.
Gov, thank you so much. Great job as always. We are so appreciative of your time and for always being here for us.